I'd like to thank you for allowing me to speak today on such a very important issue, and I'm sorry if I'm going to be repetitive. I just got to get on record. I'm going to speak to you today not as only the PBA president and a police officer, but also as a Nassau County resident, a lifetime New York resident, a father, a son, a brother, a neighbor, an uncle, and a friend. All of these jobs I take very serious. I'm just going to give you a little history on bail reform from what I know. Criminal justice reform was enacted into law in New York State in the 2019-2020 budget. The reform started January 1st, 2020. It includes no cash bail and no remand for misdemeanors and nonviolent felonies in most cases. Violent felonies, cash bail, and remand can be applied, but the judge must use the least restrictive means. The release on appearance tickets and on certain crimes are now mandatory, not officer's discretion. In crimes such as resisting arrest, the subject has to be released on an appearance ticket. My members will be required to issue appearance tickets for all petty offenses, misdemeanors, and most Class E felonies, unless the following circumstances exist. The arrestee has one or more warrants, or he has failed to appear in court in the last 2 years, or he is unable to or unwilling to verify his identity, or in certain domestic cases, or if the victim is seeking an order of protection against the subject, or if the crime that involved possibly having the defendant's license suspended or revoked, or if the subject poses a danger to himself mentally or medically. And this is very important. I know we've spoke about this over and over again, but pretrial discovery evidence. This new law places an unreasonable burden to turn over all evidence to the defendant within 15 days, including names and contact information of victims and witnesses. From what I understand, the reform was enacted because the legislature felt that there was systemic inequity of who are held for trial. They felt the people with money were freed, and the poorer subjects who committed the same crimes were remanded because they didn't have the means. Discovery changes were made because they felt the defendant was not giving all the information in order to defend himself or take a proper plea. Issues we feel we need to address in the bail reform are judges' discretion to remand, defendants getting released and committing the same crimes over and over again, subjects being released that may pose a danger to others, all subjects being treated similar. People are different, and releasing them into general population should not be a cookie-cutter approach. Some defendants, not all, are just flat-out danger to society. We need to add more crimes that to this list. And finally, give judges discretion in all cases. Issues that we need to address in the discovery laws. Currently, all evidence must be handed over and defended, like I said, in 15 days after arraignment. That has to change. It's just not enough time. This includes victims and witnesses' identities and contact information. Prior to this, defendants only got that info prior to trial. The new system is causing witnesses to hesitate to get involved and possibly put the witnesses and the victims in further fear of their safety. This system is placing criminals' cases in jeopardy, and the prosecutors cannot turn over the evidence on time. What we see as some of the solutions are give the evidence to the defendant as soon as reasonably possible and on a staggered basis. Evidence immediately in the district attorney's hands can be given over. Test results such as blood evidence, DNA, and et cetera should have a reasonable time frame so that the test results are done properly, not hurriedly, in order to have a proper case against the defendant as well as protect his or her rights for a fair trial. However, victims' and witnesses' identity should not be released unless absolutely necessary, and the burden should be on the defendant to prove why he needs this information before a trial or a plea bargain. Cases should not be put in jeopardy just because of time restraints. I ask all of you, both sides, I see both sides of the aisle, to have your voices heard in Albany. You're our voice. I got to know, all of you. You're all good people on both sides. You know this is wrong. You know this has to be reformed, and it has to be reformed now. Remember, it's never too late to do the right thing. Thank you.
Thank you very much. And, I know that Jeb talked about the morale with the ADA. Do you feel that this is having an impact on the morale of your offices?
Oh, of course. It's turnstile justice. You're at New York City. It takes a little bit longer to book somebody, and going to Central. I was a New York City cop in Brooklyn 32 and a half years ago, but just the sheer numbers alone in there. You're the guy's out on the street before you're finishing the paperwork, and that's what am I doing? What are we doing here? It's definitely has a negative effect. But our guys are professional and girls, and they're doing whatever they have to do. So we're doing what we have to do. And this is our plea to have Albany listen to you. And I heard Kavan say that let's put a letter together. Let's put a letter together. Whatever you guys have to do together, and let's get this thing done right. Thank you.